If you've ever tried to evict a tenant in California, someone probably told you it takes about 30 days. That number's wrong. And if you're managing in Oakland or Berkeley, it can be very wrong. In this video, we'll walk through exactly what the eviction process looks like in Alameda County in 2026. Every stage, realistic timeframes, and where timelines fall apart before reaching a courtroom. The full written guide is linked below. Let's get into it. Here's the honest answer to how long an eviction takes. Uncontested, right notice filed correctly, tenant doesn't respond. You're looking at 40 to 60 days from first notice to possession. Contested, tenant files an answer, case goes to trial. Plan for 60 to 90 days or more. And one mistake at any stage doesn't slow things down, it restarts the clock entirely. There are 8 stages in the unlawful detainer process, from pre-notice review all the way to sheriff lockout. Here's where each one fits, and where most cases actually fail. Stage 1 happens before you serve anything. Pull your lease, your payment records, and your maintenance records. Any open repair request at the property is the first thing a tenant attorney will look for when you file. A habitability defense can eliminate your entire rent recovery, not reduce it, eliminate it. Get that file organized before the notice goes out. Stage 2, the notice period, is where more Alameda County UD cases get dismissed than anywhere else. 3 things kill cases here. Wrong notice type. A 3-day notice to quit for non-payment instead of a 3-day to pay or quit. Void on its face, dismissed. Wrong dollar amount, must be exact. Courts dismiss over rounding errors. Filing 1 day too early. Post and mail service adds 5 calendar days to the notice period. Miss that, and you're dismissed. Oakland landlords. These 2 rules catch even experienced owners. First, Oakland's Just Cause Ordinance requires a minimum 30-day notice for non-payment, not the standard California 3-day notice. A state form notice on an Oakland property is defective on its face. Second, the amount owed must equal or exceed 1 month of HUD Fair Market Rent for that unit size, not the tenant's actual rent. If your tenant pays $1,000 a month under rent control, but the HUD Fair Market Rent is $2,000, they need to be $2,000 behind before you can serve. At $1,000 a month, that's 2 months behind before the clock can even start. Below the threshold, the notice is defective and the UD won't survive. Once the notice period expires, you file the unlawful detainer complaint with the Alameda County Superior Court, Renee C. Davidson Courthouse in Oakland. The court then issues a summons that must be personally served on the tenant. It cannot be mailed. Service takes 3 to 7 days. The tenant's response window begins the day after service. After service, the tenant has just 5 calendar days to respond, much faster than the 30 days in regular civil court. But in Oakland and Berkeley, tenant legal aid organizations are well-funded and actively advertise. The contested case rate in Alameda County is higher than almost anywhere else in California. Plan for a contested case. Don't assume a default. No tenant response. Request a default judgment within 1 to 3 court days, getting you possession and any rent claimed. Tenant responds. Trial within 20 days, bench trial, judge only. The defense that blindsides landlords most often is habitability. An open repair request when you file can become a defense that eliminates your entire rent recovery. Not reduces it, eliminates it. After judgment, you request a writ of possession and deliver it to the Alameda County Sheriff's Civil Division. This is where owners are consistently surprised. In our experience across Oakland, Berkeley, Emeryville, and Albany, it typically takes 2 to 4 weeks from writ delivery before the sheriff even posts the 5-day notice on the property. That's not 5 to 10 days, 2 to 4 weeks just to get to the posting. Then 5 days for the tenant to voluntarily vacate. Then the sheriff returns to execute. Total from writ to possession, 3 to 5 weeks. The court moves in days. The sheriff moves in weeks. That's the real timeline. This is non-negotiable. No locks changed, no belongings removed, no utilities shut off at any point before the sheriff executes, even after judgment, even while the writ is in queue. Self-help eviction is illegal in California. Penalties include actual damages, punitive damages, and the tenant's attorney's fees. Wait for the sheriff. 4 things push timelines from 40 days toward 90 or beyond. A defective notice that restarts everything. A habitability defense with a separate abatement hearing. A sustained demurrer requiring refile, or the sheriff's queue, which is baked into every case. In any contested UD, what you can prove matters more than what happened. Signed lease, Organized payment records, time-stamped maintenance records, everything in writing, notice and proof of service. For Oakland, just cause cited on the notice face. Build that file before things go sideways. At all East Bay properties, we maintain this documentation in AppFolio for every property we manage, from day one. When we need to pursue a UD, the file is ready. We're not assembling records the morning before trial. That's what allows owners to move quickly through a process that too many landlords learn is more complicated than they expected, after it's already gone sideways. The full written guide, every stage, every citation, complete Oakland requirements, is linked below. If you're navigating an active situation or want a team that handles this so you never have to, visit leastbayproperties.com to schedule a free consultation. Next in this series, self-help, eviction penalties, and owner protections. Thanks for watching. From all of us at All East Bay Properties.